Well, it's just gone 22 minutes to 7 on this Tuesday, and I hope Worksmans have got some good IP protection over that advert. It's had everyone laughing here in the studio. It's a good one. And it's time for our second law panel this week. Just to recap, we started with a bang last night discussing the role that competition law and policy has to play as one of the key drivers to help lower barriers to entry in the South African economy. And I think our panelists agreed to disagree somewhat with the Centre for Competition Regulation and Economic Development at UJ and a new study that they'd published. Certainly the consensus was that our regulators could do a much better job in regulating the sectors that were targeted in that study. ICASA, for example, certainly sprang to mind. Tomorrow night we're going to discuss the decision taken by government to review all legislation passed since the advent of democracy. That's over 1,000 laws, and whether or not there are any gaps. We're also going to assess the impact that these have had in the main, the good, the bad, and the unintended and the intended. And I think ultimately it really speaks to the conversation we're having in the country at the moment to have far better regulatory impact assessments or socio-economic impact assessments, whichever word the government's using at the moment. And then we're going to round everything off with what has gone wrong in South Africa's land reform program and how it might be improved, and some interesting guests for you on Thursday night. It's all about the law on the panels this week, brought to you by Worksmans. Now, tonight we're going to be talking about indigenous knowledge, and I think South Africa has quite a long and rich history of biodiversity, which has been mined by commercial enterprises that saw little need to share the benefits of that commercial success with locals. This is changing as the state places more emphasis on the value of indigenous knowledge, and it's embodied in the Protection, Promotion, Development and Management of Indigenous Knowledge Systems Bill. It's quite a mouthful, that, and it's seeking to balance the rights of indigenous knowledge holders with those of researchers and businesses that want to commercialize this knowledge. And it speaks perhaps, I think, to a clash of approaches. Well, I've assembled an expert panel of IP knowledge holders, shall I call you, tonight, to help us find out. In studio, it's a great pleasure to welcome Andre van der Merwe, Director of Quiche IP. Andre, great to have you in studio.
Evening, Michael. Good to be here. Thanks to your listeners.
And in studio with us is Tertia Beharie, partner at Spur & Fisher. Tertia, thanks so much for braving the wild weather to come down to Braamfontein and talk indigenous knowledge.
Thanks, Michael. Thanks for having me.
And all the way in Turkey is Susanna Chung, Director of CS Consulting. Susanna, thanks for joining us from Turkey. I hope everything has calmed down.
Thank you, Michael. Thank you for having me on the show. And yes, for now, things are calm in Turkey, we hope.
We hope. Well, it certainly does seem to have calmed down. But we haven't brought you onto the program to talk about global geopolitics. We're talking about indigenous knowledge here. And Andre, perhaps you could just kick us off. The bill, shall we call it the IKS or the X bill? I don't know what you call it for short, but I certainly don't want to be calling it the Protection, Promotion, Development, whatever it else is the whole night. So let's call it the bill. But before we talk about the bill in its current form, perhaps we should just take a step back and understand why it came into being. What are the key policy drivers behind recognizing indigenous knowledge?
Michael, I think the background to all of this was that in about 2000, the government took a decision that it should look at the protection of traditional knowledge and traditional cultural expressions. And so 3 departments got together, the DTI, the DST, Department of Science and Technology, and the Department of Arts and Culture. And they, between the 3 departments, they produced a policy document. And the policy document suggested to government that government should look at ways to not only protect traditional knowledge and cultural expressions, but also that it should look at ways of assisting indigenous communities to commercialize that knowledge, if at all possible. And then a process started out with the DTI, I think in 2007, and they produced a bill. in which they grafted traditional knowledge onto intellectual property laws, 4 of them: Copyright Act, Trademarks Act, Designs Act, Performance Protection Act, and that bill had a very checkered progress and a long, rather tortured process, but eventually it passed through to law in 2013, and now we have this bill, which tries more to protect, I think, traditional knowledge as such, rather than it also seeks to protect, of course, cultural expressions, and to that extent, there's an overlap now between an Act of Parliament from 2013 and this bill, which has just gone to Parliament earlier this year. So that's the background to it, and it certainly raises some questions and some problems.
And Susanna, I mean, thank you, Andre, for the wonderful introduction and contextualization. I think that is the issue here. Looking at this, it does seem to me that we wanted a sort of sui generis protection, which is a broad protection of indigenous knowledge, but then we almost went in another direction when we grafted, as Andre said, the rights and protections into existing law.
Yes, Michael, are you talking to me?
Yes, sorry. No, it's always difficult when you're talking to someone who's at least 13,000 kilometers away now. But this does seem to create this overlap that Andre was talking about, and a sense of confusion. I mean, why do we need the Indigenous Knowledge Bill if we've already crafted it via our existing laws?
Well, Michael, this is a long debate that's been taking place also on the international level. For what Andre has added, just to add, is that there is the World Intellectual Property Organization in Geneva, Switzerland, that has also been long discussing this issue since the 90s, of the whole issue of protecting indigenous knowledge, folklore, genetic resources. And the question is, as the organization itself is mandated to protect intellectual property rights, the question has been whether intellectual property law has been the right forum or the right manner to protect indigenous knowledge, or whether we require a sui generis law to protect it, because indigenous knowledge itself does not conform into the current framework of IP law. And that's been the debate for many years, and it's still ongoing, I know, in Geneva. So the question is, and that is where South Africa has taken that step forward, where the DTI has tried to incorporate indigenous knowledge protection into current existing IP law. But it also shows, the IP Amendment Act does show that there are certain gaps that still need to be filled, and this is where the bill itself comes through with its sui generis protection.
Right, so to fill in some of those gaps as well. And when we look back at the global divergence on the way this has been approached as either an IP issue or a sui generis issue, is there a clear split here between sort of the developed world on the one side and the developing world on the other?
Most definitely, there is a clear split between the developed world, which are mostly the ones that are patenting most of the indigenous knowledge, versus the developing world where the indigenous knowledge is being held. So until such time where an agreement will be reached, which it won't, this question will continue. So South Africa, as a lead member of a developing world negotiation in Africa, has taken its step forward by putting it in a sui generis legislation and showing how it could possibly work. And hopefully this will be incorporated at the international level. Right,
so we're world leading here when it comes to this particular piece of legislation, which, well, let's hope we get it right, because it might be something to be proud of. But by the sounds of things, it's going to create a lot of debate still, certainly at WIPO level. Tertia, when we look at what forms of indigenous knowledge the bill covers, what does it state in the preamble? And perhaps you could just flesh that out into the sorts of things that we're trying to protect here.
Yes, Michael. The bill does provide a very detailed definition of what indigenous knowledge covers. And it also provides a definition for indigenous cultural expressions. And in essence, what it means is that we're looking at the protection of South African indigenous biological resources, and that I mean plants that are indigenous to South Africa, as well as knowledge of a scientific or technical nature that belong to a specific tribe, knowledge of natural resources, as well as indigenous cultural expressions. And there we're looking at songs, folk dance that also belong to a specific tribe.
Now, the issue for me here, Andre, is when we're talking indigenous knowledge and expressions, it's very difficult to find out who the original author of that is. It seems to be that we're applying a homogeneous kind of categorization to something that is quite a lot more abstract than perhaps one might be able to touch or feel with a recorded CD or a book or something like that, where we're talking about expressions, cultural expressions, designs that may be similar to other designs in the rest of Africa. I mean, when it comes to pinning down exactly what indigenous knowledge is, how is it registered and how is that approached through the bill?
Well, Michael, this bill, aims at registering indigenous knowledge and indigenous cultural expressions. Exactly how that will be done and how easy that is, I think still has to be discovered, because it hasn't properly been done yet, and so it's going to be a voyage of discovery. But what I'd also like to say, of course, is the difference and the difficulty here is that many of these cultural expressions, for example, songs and poems and artistic works, come from many hundreds of years back. Or maybe even thousands of years. So it's impossible to know who the author or authors were, and these have probably changed over the centuries. That's the one aspect. The other aspect is that certain indigenous communities share these various cultural expressions. That's the one thing. The other thing is, and just before we came on air, we were having a little chat, and I was saying to Tertia, I think as far as the medical and the agricultural and scientific thoughts and ideas and knowledge is concerned, I don't think the Sangomas will easily part with their top secret knowledge, which they guard literally with their lives, to have it registered. And I noticed that they do have a provision in this bill that once it's registered and someone wants a copy of it, you have to sign a non-disclosure agreement. So it's a kind of it's not like the patent office where you can walk in and pay your 20 Rand and get a copy of this patent specification. It will be kept by the DST under conditions of considerable secrecy.
But is the Department of Science and Technology, and I share your concern, going to be able to convince a traditional healer, Sangoma, of the sanctity of their rights under this legislation? Is the trust there? Is the understanding there? And who's going to drive this process? Tertia, I'm going to throw that one to you. It's a bit of a hand grenade, but these are the knotty issues.
Yeah, that's a difficult one, Michael. It remains to be seen, really. And the other thing is that the bill provides for a 12-month period for everybody to come forward now to register their indigenous knowledge or cultural expressions, and I don't think that's sufficient time, given the vast, the diverse, different cultures that we have in our country.
If you just look at the cultural record we're talking about here, I mean, you're probably looking at a project that is, multi-year, sort of, not even, I would say, a decade at least, to try and document all of that and then get it registered. Before we take a break, Susanna, is the onus to register on the communities, or is the DST going to take the lead here and try and document all of this itself and build up a registry, a national database? How is it going to work?
As far as I'm aware, Michael, I think DST has been working on a database for quite some time now. So I would assume that they are integrating this concept into the bill so that it is feasible within the 12-month period. But I do agree with Andre and Tertia in terms of this registration point, that it is quite tricky to require communities to register their Indigenous knowledge, especially those that are in rural areas which may not have access to be able to come to the DST or NIXO. So I think the onus should most probably be on DST if it has to be, but I do at this stage personally don't think the registration idea is the best way forward in protecting Indigenous knowledge.
Well, as Andre said, we're having a chat before the panel, and it seems like you're in agreement there with Tertia. And Andre, you took a slightly different approach. Just I said we're going to break, but just quickly before the break, your approach is different.
Yeah, Michael, I thought that possibly the way to try to protect traditional knowledge and these cultural expressions would be not to register them, but to protect them by way of law, almost as, if you like, for our listeners possibly to understand it better, to protect them almost as a cultural right. And of course, if there was misappropriation, those people, yes, it may be a bit more difficult if you don't have a registration certificate to go to court to stop such misappropriation, but I'm sure that's not happening, on a grand scale. But I would rather like to think that one made it as easy as possible for the Indigenous communities. But that's my take, Michael.
But also why we're probably going over to a sui generis type system as well. Well, we just have to take a quick break from this panel, brought to you by Worksmans. Well, welcome back to Classic Business, brought to you by Worksmans. We're talking about Indigenous knowledge and the Indigenous Knowledge Bill that really is seeking to afford a greater level of protection to Indigenous knowledge holders here in South Africa. I've got in studio Andre van der Merwe, Director of Quiche IP, Tertia Beharie, Partner at Spur & Fisher, and on the line Susanna Chung, Director of CS Consulting. Tertia, the patent laws were amended recently. How do they fit into this huge jigsaw puzzle that we have to protect Indigenous knowledge holders?
Michael, it actually wasn't recently. It was a good few years ago. And there really is an overarch between this bill and the amended Patents Act. And what the Patents Act says is that if you're working on an indigenous biological resource or traditional knowledge, and you've done work on a specific plant, for example, and now there's an invention that has come through from all of that research, that application for a patent has to be accompanied by a declaration which specifies whether this invention stems from a South African biological resource. And if that declaration is positive, then your patent application has to be accompanied by other supporting evidence to say that you've consulted with the community, the Indigenous community, you've got prior consent from them, you've entered into the necessary benefit sharing agreements, such that if you're going to get royalties from your invention, some of the royalties are going to go back to the community to uplift them.
That is quite interesting, and we were speaking about it earlier with regards to how much work goes into developing a product. For example, that a particular plant, called the Hoodia plant, we know that case quite well, but you as a pharmaceutical drugs manufacturer go and actually do all the R&D, you isolate the exact compound, you still need to pay over the fair due to the Indigenous knowledge holder.
Yes, Michael, that's correct. That change came about in,
I think, 2005.
Yes, late 2005, 2006. Yeah. And since then we've had the Hoodia case, the Rooibos, and Pelargonium.
Yeah.
So, I mean, we do have a system that sounds to me like it is working. So, in other words, if it ain't broke, why try and fix it, Andre? I mean, why are we trying to go off into this sort of world first direction with this piece of legislation?
Yes, Michael, that's a very good question, because in law, one doesn't really want to stick your chin out and be first, because if you get it wrong, then it's very embarrassing. And South Africa already has an act prior to this, a 2013 Intellectual Property Laws Amendment Act that we referred to earlier, and as Tertia mentioned, it's not the right vehicle to protect indigenous knowledge and indigenous cultural expressions, because those are cultural things, as the name suggests. They're not business. They're not really designed in the first place to do business with. They're cultural things like language. Language is developed not to make money with, but it's just part of a community's cultural richness, if you like.
But they'll still profit from it.
Yeah, yes, indeed, you're right. And the Western world, unfortunately, has a bit of a history of, especially, of abusing natural resources, and when they find something that has medicinal value, they're inclined to send in people, and they try to take it all off the land. And that was one of the first concerns that was raised by the world community, as Suzanne has mentioned. That was the first problem, namely, stripping natural resources. That's where this whole concern came along, and then it developed into further things, because people saw that there were other aspects. Think of the songs and the stories, and the artistic works and the dances and all sorts of things. And I just want to point out, Michael, here that I've got a copy of the bill in front of me, and I just want to read one line. Any person who uses indigenous knowledge without authorization shall be guilty of an offence and liable on conviction to imprisonment for a period not exceeding 3 years or a fine of 30,000 rand or both. So you can see government takes a pretty strict view of protecting intellectual, this indigenous knowledge and the cultural expressions.
Well, and I'm happy to see that it does, because certainly I think for far too long indigenous communities have been brushed aside when it comes to these things. And as we said right up front, I think the developed world has realized that and is more than happy to go in this direction. Unfortunately, that's all the time we have for tonight. We're running a little bit over, so thanks to all of my guests tonight. Andre van der Merwe, Director of Kish IP, also in studio Tertia Beharie, partner at Spur & Fisher, and on the line Susanna Chung, Director of CS Consulting. For me, Michael, producer Amol Khlakla, and sound engineer Ndu Tele, thanks so much for tuning into this law panel, All Indigenous Knowledge Rights Reserved, which is brought to you by Worksmans. Good night.
Need to warm up your